Welcome to the HIT Podcast, H.I.T, Human Resources, Insurance, and Technology. I'm your host, Toby Kennedy. As we do every week, we are dropping into your feed with what I hope are bite-sized, digestible, but very well curated conversations important to the goings-on in the space for those of you in Human Resources, Insurance, and Technology. This week's episode is brought to you by Montage Insurance Solutions. I'm super excited to get into it. Let's jump right into it. We have Brian, rarefied air, by the way, my friend. Rarefied air. You are one of a very, very few, I think maybe number 2, repeat guests, brother. Welcome back.
Hey, it's great to be back, Toby. Always love to be able to chat with your listeners and try to drop some knowledge and make them better than what they were yesterday.
I appreciate it. That should be the tagline for the show. We're going to have to re-record so that I say it first, so that for the record, it was my idea. Speaking of things we have said before, you were on the show and you did the 10 Commandments of Workers' Comp, and I thought it was a wonderful episode. It was incredibly well received. A lot of great information. So if you like what you see today and you didn't see that episode, go back and watch it. But on the way out, we were chatting, and I said, Brian, I got to be honest, man. You are an absolute rock star with a ton of knowledge and a topic that I just you can't talk about enough is leave laws. Do you happen to know anything about that? And you said, Toby, my friend, say less.
Yep. And I got to tell you, this and wage and hour law are the two big things in California, especially.
Look, he's already teasing his sequel. He's already teasing his what do they call it? The trilogy. The trilogy.
Right. I love it. Hey, good. I gotta drum up support, drum up work. Right.
I love it. No, look, as you said, I mean, all jokes aside, I've been doing this for almost 20 years, and I've sat in on a million of these types of seminars, and they always fill out because there's so much going on. There's so much complexity. There's so much nuance. There's so many landmines that one could step on. And for an HR practitioner that's expected to know 10 trillion things and also this, it's tough, and you almost can't hear it enough.
I couldn't agree with you more. And unfortunately, when they keep moving the goalposts on us, HR directors who were great at what they did 5 years ago are standing back going, well, wait a second, I'm not as good with this new change to the law. So staying on top of it and making sure that you're educated is a key element of any HR professional's role.
Yeah, completely agree. And so that's where we have shows like this. And part of the reason I say bite-sized and digestible is because, we try to get right into it. So, enough two buddies, yucking around and joking around. Take me through the landscape of leave laws, man. Let's get right into it.
Well, sure. And depending on the size of the business that you work for, it really depends on which leave laws apply to you. And we're going to talk about a few of them today, one from a very general standpoint, but then we're going to get down into a little bit of the weeds. So first and foremost, everybody in America has already heard of the Family Medical Leave Act, FMLA. This applies to all companies nationwide that have 50 or more employees total within the business, not 50 or more per location, not 50 or more in the Western United States. It's 50 or more company-wide. And so this applies to most of your listeners, Toby, because you've got larger companies that have 50 plus people. But the FMLA rules have been around for a long time. We've refined them and ratified them and modified them over the last 10 or 15 years. But really the core of this stays the same for the last 35 years. And what it comes down to is this. If you have an employee who has an injury or an illness, or if they've got an immediate family member who has an injury or illness where they have to provide care, you must provide them with 12 weeks of unpaid leave that will be able to provide them with an opportunity to go and take the care and receive the care that they may need or that they need to provide for a loved one. And they get to have job protection as part of that leave. That means that you cannot take any adverse employment action against that employee during the time period that they're in their protected leave period of time. And, depending on which states you're operating in, each state has their own version of FMLA. In California, we call ours the California Family Rights Act. But here, you don't have to have 50 employees in California. You only have to have 5. So even you super small employers, you mom and pop organizations, if you have 5 people who are your employees, you will qualify for that same leave obligation, which means you must allow someone to take 12 weeks of unpaid but job protected leave while they care for somebody within their family or their own illness.
Or what?
Well, then you're probably facing a claim for failure to provide those accommodations that are required by federal or state law. And in those circumstances, the obligation falls squarely upon the employer to comply. This isn't one of those things where you can point at the employee and their performance or their issues that they had prior to their leave, or you were just upset, or you even realized while they were away on leave, heck, I really don't even need this position because we've been just fine without the person. It is a truly job protected leave. And if you fail to reinstate the employee to the same or the substantially similar position that they were in prior to their leave, that is a violation of either the FMLA or the CFRA, California Family Rights Act, and an action can be filed against you in civil court.
I'm obviously I'm not the attorney in this equation, but I can't you just say I didn't know?
No, ignorance of the law is not a legal defense. I cannot tell you how many times I've told this to clients over 24 years. It is absolutely, you are charged with knowing and understanding the very minute portions of the FMLA and the CFRA. And if you do not, it is not a defense that you didn't know. And in fact, you are presumed to know because the information is out there and available to you.
On lovely podcasts like this. Yes, the old Dave Chappelle's got a joke which says, I didn't know I couldn't do that, right? It gets away with it. Yeah, not here. So maybe if we are listening, we've now been sufficiently scared into turning up the volume or paying better attention. Talk me through some of the mechanics.
Well, some of the mechanics, the most important mechanics, and I say this in a lot of areas, but documentation is absolutely key. From the moment an employee walks in the door and has a doctor's note that says that they need to be out on any type of leave beyond a small flu or bug where they're going to be out for 1 or 2 days, right? If you've got an employee who's going to be out for 3 days or longer, you should have a policy that basically states the moment you receive that doctor's note, it triggers your documentation procedures. How do we document it? First, we acknowledge receiving their doctor's note saying, we understand your doctor says you need to be out for X number of days or weeks or months. And here are your rights. In California, for your California employers, there are actually 2 pamphlets that also have to be provided to the employee so that they know what their rights are under the law and they understand what it takes if they need to go and get wage supplement from the state through state disability insurance. We basically lay out what their rights are. We tell them how long they're going to have job protection. We advise them of what benefits we are providing them as an employer while they're out. Keep in mind, currently, these are all unpaid leaves, meaning you as the employer do not have to pay the employee, but you should, in your written policies, have something that states that the employee can use any accrued sick time, any accrued vacation or PTO, depending on how your company handles it. And then you tell the employee what they need to know in order to get paid if they would like to use their sick or their vacation or PTO. And then our other obligation here is that we have to remain in contact with the employee throughout their leave. There is an interactive process that works into all leave laws. And what that means is you as the employer, you don't just get to set it and forget it. You have to stay in contact with them. If you've got a doctor's note that says they're out for 4 weeks, then you should be reaching out to them a week beforehand saying, listen, your doctor took you out for 4 weeks. We need to know whether or not you're going to need to extend your leave of absence or whether or not you're going to be returning to work so that we can plan and prepare for your return. And then on the back end, whenever the employee is ready to return to work, we also document through what's known as a fitness for duty certification, something from a physician that says this person can safely return to work and they can perform all of their job functions. Now, a lot of the times we get doctor's notes that don't let them do all of their job functions. Sometimes they have to work remotely. Sometimes they can only work part-time. Sometimes they can't bend or stoop or lift or do other portions of their job that they would normally be required to do. And that triggers the employer's obligation, once again, to interact, engage with the employee, communicate with them. And then if you have a telephone conversation with them or a text conversation, you back it up with documentation. You send a letter, you send an email to show that you have done what you're obligated to do under the law.
And obviously, for anyone over their skis, you or someone like you, a nice attorney, it's like, hey, we can help you write these policies in the first place. And if you feel to leave, call us. We could talk you through kind of when to go through these, how to call, how much, how often, and documenting all those things. And so for the more kind of seasoned practitioner, are there changes that or maybe certain pitfalls you see where you're like, listen, I'm not talking to the basic HR person. As I said, my phone number, my email is out there. I can really put an arm around that guy's shoulder. But if you're listening and you're more seasoned, here's some tips and tricks I've seen that trip up even the best of us.
Well, even the best of HR professionals still have a very hard time understanding the interaction between what we're talking about right now, the FMLA and the CFRA, the mandated federal and state leaves that guarantee job protection, and then the other obligations that come into play, such as the ADA, Americans with Disabilities Act, or the FEHA, Fair Employment and Housing Act here in California. Even if an employee doesn't meet the qualifications for these mandated FMLA or CFRA leaves, we still have obligations to communicate, to interact, and to provide a reasonable accommodation for individuals who have a disability or an illness or need to take some small time periods off. For instance, if they have to go through extended treatment or care for a severe illness. We do still have those obligations. And all too often, I see folks in the HR field who simply say, well, we gave them their 12 weeks of CFRA leave, so we don't have to worry about anything else. That is absolutely positively not true. There may be additional accommodations. There may be additional obligations upon you as the employer. And remember, the deck is stacked against us, folks, as employers, right? The laws are written to favor the employees. And if we don't do what we're supposed to do from the employer's standpoint, then we have violated the law, and that would expose us to liability if a civil claim was ever filed.
How about, because what I see also being a little bit tricky for folks is things that run concurrent, things that run back to back.
Pregnancy disability leave is the biggest example of that, Toby. I will tell you, all too often, employers get this so very wrong. Understanding that if you have a pregnant employee, we joke about this within the defense bar, those of us that counsel management and businesses. Pregnancy is the holy grail of protection in the law. If you have an employee who is pregnant, not only do you have to make sure that we are doing everything properly, that we're documenting each step, that we make sure that we're providing the greatest accommodations possible available, but we have this scale that has really got many overlapping elements. An employee who, for instance, is a resident of California, she would be entitled during her pregnancy leave to both pregnancy disability leave, which overlaps with FMLA, but then the CFRA is separate and distinct on pregnancy leave because that is to be used for baby bonding time after the birth of the child. And then you want to throw in another mix on this. We also have something in California called PFL, paid family leave. And that also begins from 8 weeks from the date of the child's birth moving forward. So you could have an employee who feasibly could take up to 29 weeks off of work on a fully job protected leave, depending on how her disability falls, if she has to be placed on bed rest before the delivery, all the way until 12 weeks after the delivery before she is required to return to work. And during that time period, the burden falls upon the employer to A, make sure she has ultimate job protection and that she's restored to her position once she's able to return to work. B, we have to continually engage and interact without harassing the employee, right? We walk a very fine line on how frequently we communicate with the employees. And then 3, ensuring that when the employee comes back to work, that we have all of the other obligations of a new mother who returns to the workplace. That would include lactation accommodations, additional time off if she needs to express breast milk during the workday, other obligations that overlap with all of these other standard leaves. And all too often, employers mess up in the calculation of the time period that they have to allow that employee to stay off.
Yeah, and you're talking about things that sort of overlap and that almost become confused for one another. And I'll tell you my experience, I think another important delineation is, as you've said a couple of times, job protection being different from income replacement, right? Absolutely. And so especially when you overlap, for example, a disability policy, right? So we've got someone that says, hey, we have a 60-day elimination period and not everyone lives in California anymore, right? Everyone's scattered to the wind during COVID. So now I've got this employee in another state, which almost none of them have state disability income replacement. And so
Correct.
we're looking to see how will our disability policy perform that's got this 60-day elimination period. It's like, well, you might be having conversations about job protection and baby bonding and those things, but more often than not, you get either 6 or 8 weeks of sort of disability, meaning I can't perform the essential functions of my job unless there was a complication, right? As you said, maybe you're in labor for a month or two, or God forbid, beforehand, or really bed rested after, or, postpartum issues where it's like, hey,
Yep.
now I have a physician saying I cannot perform the essential functions of my job. And that's another different kind of layer that weaves into this sometimes.
Well, and quite candidly, this is one of the big issues on the political platform right now at the federal level, which is providing pregnant employees and women who have just recently delivered with a paid family leave on a national level. So that's something that we're keeping our finger on the pulse right now, because there's been a huge movement nationally. But there are states individually who do have replacement through state disability income. There are other states that don't. And many of the employers that we work with have elected, knowing that this will be a financial hardship on a family, to find some sort of compromise, whether that's through an insurance policy with a disability plan for pregnant employees so that they can be covered during that time period so they've got income replacement, whether that's a partial income replacement paid by the employer, him or herself. These are all decisions that you should sit down with legal counsel, talk through, and make a determination as to what makes the most sense economically, but also for the best interest of your employees. Because quite candidly, finding and retaining good talent is one of the biggest issues in our labor market.
Yeah.
If you've got somebody who is otherwise a great worker for you who needs to take a leave of absence, we may want to do more in those situations, but we have to be careful, because if we do for one person and we don't do it for another person who's similarly situated, now all of a sudden we run afoul of discrimination laws.
Yeah. 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 Especially if, inadvertently the person we did something for was of a different religion or, gender
Correct.
or background or something, and then the other person wasn't. It's like, wait a second. You're doing this for your Australians and this for your New Zealanders. That's no bueno, right?
Right. Precisely. I couldn't agree with you more.
Yeah. So we talked a little bit about like concurrent versus non-concurrent. We talked a little bit about income replacement versus job protection. We've talked about, a few of the pitfalls. Curious if in your experience, anything else kind of comes to mind to touch upon when we're discussing the topic of leaves.
Well, the one other thing that I just want to talk about here real quickly is when we have an employee out, all too often employers think, oh my gosh, there's nobody to do this job, right? We have to go out and hire someone else. Well, the problem with that, of course, is the fact that you do have those reinstatement requirements at the conclusion of the leave. You have to bring that person back to their job or something that was substantially similar to their job. So if you choose to hire, for instance, a temporary employee, that's perfectly acceptable. We have a number of clients who like to go through staffing companies to bring in temporary services to help them in the interim period. There are other clients who simply say, we'll just disperse the work to the existing workers who are in the workplace. And this is an area where we also see a huge problem. Why is that? Well, guess what? If somebody is doing not just their work, but a third of their coworker who's out on leave, how do you think that coworker is going to be treated when they return, right? Everybody's going to be really upset because they're like, well, we had to pick up the slack and we had to handle all of your workload on top of our workload for the last 3 months while you were out, and it's time for you to get back to work. And it can be viewed as a retaliation situation. And we have to make sure that we're taking affirmative steps from an HR perspective to ensure that retaliation doesn't take place once somebody comes back to work. Why? Because we have express laws on this. No one can be discriminated against, harassed, or retaliated for taking an approved leave of absence that's guaranteed under either federal or state law. So communicating with the rest of the team, making sure that they understand, how long is this person really going to be out? Yeah, they tell us now that it's only 2 weeks, but we are seeing the writing on the wall and we think it's going to be longer. Communicating with your teams, making sure that they understand what to expect, understanding that if it does fall upon them, that there will be some grace given there. Because the last thing you want to see is having your existing team who's picking up the slack while one person's out go down. out on an anxiety leave, or they feel stressed at work, and then a workers' compensation claim may be filed. These are things that we see happen all the time when we're down a person on our team, in our department, or in the company if we're a smaller company. So just be thoughtful on that. And
Yeah,
then
that's
I'll pause
interesting. And yeah, sorry, I just it triggered a thought for me, but it's like obviously the first answer to the question I'm about to ask you is use good judgment, you silly goose, right? But my question for you is professional advice on riding the line between, as you said, I need to communicate with my employees, but some of the stuff might be private, or I'm talking about my employees' leave. Like,
there.
how do I communicate that properly?
Sure. So that's a great issue. So understand that any employee who has any sort of disability, illness, or injury, they have privacy rights under HIPAA. You don't need to share the what of why someone is out, just simply that they are out and how long we anticipate it to be. In fact, if you were to disclose, well, we just found out that John has cancer, that's actually a violation of HIPAA laws. So
Right.
we can't share the details of why the person is out, just simply that they are out and where we believe how long they're going to be out so that we know who needs to do what in the interim period. So yes, you're constantly walking a fine line. When I tell employers less is more, I
Yeah.
can't emphasize that enough.
Yeah.
Don't give specifics. And quite candidly, you as the employer shouldn't really know the specifics. The doctor and the employee aren't required to disclose it. Now, all too often, especially in smaller businesses, we're all a tight knit community, right? And people are going to know when someone is out ill for an extended period of time, and they'll start asking questions. Is John okay? Should I call and check on him? The answer is you guys do what you need to from a personal standpoint, but all communications from the business are being handled through our HR team or whomever you've designated to be the primary point of contact. And that's
Yeah.
another important point. You should have one point of contact whenever
Yeah.
possible, because what we don't want to do is when someone's out on leave, having them field 5 or 6 or 10 questions.
Mm.
Remember, when they're off on leave, they're not supposed to be doing any work. They're not being compensated because they're off on a leave. You need to honor and respect that. So if there are questions or, hey, Jane, where did you leave the XYZ file before you went on leave? It should all go through a primary channel, a singular point of contact wherever possible.
Yeah, and that's an interesting note. Like you said, okay, so let's say our primary contact, is HR or whatever, right? And so as a manager, if you're asked, let me restate this to make sure I heard you properly, but maybe good advice for the manager who feels the question on, hey, some of us are a little bit aware of why John went out. Just want to check in. Do you know if John's doing okay? For that manager to really kind of punt and just say, if you guys are checking in with John, check in with John. But from a company standpoint, that's really all running through Susie.
Ideally, yes. While there's no one size fits all, and all companies are different, and the tightness of a group may be very different from department to department, I just caution employers to be very careful about it. Because, for instance, if someone went out on a stress leave, right,
Mm-hmm.
and the source of their stress was their manager, guess who the last person is that they want to hear about from during their leave? It's that,
Oh yes, the manager.
right?
Yeah.
And that's why if you've got an HR department or someone there that can handle that, I always recommend that it be filtered through that person, and then the HR person can send it to the manager and the manager can distribute it accordingly. But in the event that you're a small company where you don't have an HR department, it may be that the manager has to be the primary point of contact,
Mm-hmm.
where the manager has to know when John or Jane is returning to work because of workflows or deadlines, etc. These are things that really become a practical issue, and it's really important for you to connect with either, if you don't have in-house HR, having an outside HR consultancy
Mm-hmm.
or competent legal counsel who understands the intricacies, because it is really a fact-driven scenario in that
Mm-hmm.
situation.
I feel like our conversations always go so fast, and you have so much knowledge. And we did talk about the trilogy. Before we get out, just while we're on the topic of leaves, are there any last thoughts or kind of buttons to put on anything we've discussed?
Yeah, first of all, I just want to make sure I focused on documentation.
Mm-hmm.
If you don't have a checklist for leaves of absence, you should develop one. Or if you have counsel, I'm sure
Call
that
Brian.
one,
Yeah.
yeah, give me a call. I've got a checklist for you. It lays out every step of the way on where you should be documenting, what you should be documenting, how it's important to make sure that you follow the same procedural steps each time, and that you back all of it up with writing. I can't tell you, all too often people are just very casual about these type of interactions, and then there's no documentation, and we have to go back and recreate the timeline in the event that there's a dispute later on down the line. And candidly, people's memories fade. I don't know if that happened on a Tuesday or a Thursday. These are the types of things that the documentation will be your saving grace in the event that there's ever a dispute. Secondarily, it also gives you a written record so that you know if there are employees who take advantage of your leave requirements, that you're going to know who those people are very quickly.
Yeah, and as you said, not only do memories fade, but unfortunately, we've all kind of seen relationship strengths fade and sour and stuff. And you think, there's no problem. It's this guy. We're really cool. Go ahead and dot all your I's and cross all your T's, because stranger things have happened.
Yeah, we're only friends until we're not, is the statement that we tell clients all the time.
Yeah. Well, and everyone's kind of the hero of their own story. So they remembered a little bit different, or they felt slighted in ways that maybe, you weren't intending. Thank you so much for joining us, Brian. I appreciate you so much, man.
Anytime, Toby. I really enjoyed chatting with you and getting to know the folks that listen to your podcast. And I'll be on standby anytime you're ready for part 3 of the trilogy. I'll gladly step in for you any day of the week. You know it.
Wage and Hour coming 2025. Thank you so much, man. Well, that's all the time we have for you here today. Join us next week. Join us every week. Thank you so much to our sponsors, True Hue. Thank you guys for joining us. And until next week, make this the best week yet.